I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. A federal magistrate judge from the Eastern District of New York has just issued an order that the identities of the suretors and the proceedings relating to the suretors who posted $500,000 in bail for disgraced MAGA Republican Congress member George Santos, that their identities be released. George Santos was given until June 9th, 2023 to file an appeal to this order. The order itself is under seal, but we have the docket entry. This comes from Magistrate Judge N.Y. Shields. Here is the order that just issued. For the reasons contained in the attached order, the motions to unseal the identities of the suretors who signed the bond for defendant's pretrial release, filed herein at docket entries 13 and 14, are granted to allow defendant, George Santos, to appeal this ruling to the district court. The clerk of the court is directed to maintain the attached decisions and all previously sealed documents, including this bond, under seal. Any appeal of this order must be filed by noon on Friday, June 9th, 2023, so ordered by Magistrate Judge N.Y. Shields, dated June 6th of 2023. Just to give you a sense of the federal procedure here, the Magistrate Judge, Judge N.Y. Shields, she would normally preside over things like the arraignment, over the posting of a bond, over hearings related to the posting of bonds, hearings relating to the execution of search warrants, signing search warrants. Those are tasks of the magistrate judge. Ultimately, there would be an Article 3 federal judge who's presiding over this case. And so what Judge N.Y. Shields is saying here is that George Santos would still have an opportunity to appeal this ruling to the district court judge from the Eastern District of New York presiding over his criminal case. However, I don't think that has any chance of succeeding, and the deadline for George Santos to file that is June 9th of 2023. So let's rewind for a second to remember how we got here. George Santos was indicted on multiple felony counts for lying to Congress, engaging in wire fraud, and engaging in fraud relating to the accepting unemployment benefits when he was not unemployed. There was a $500,000 bond that was posted to bail him out. The identities of the suretors who posted the bond remained under seal. They petitioned to keep their names confidential, and until that is challenged, it remained under seal. But last month, it was challenged by the New York Times, the Washington Post, and several other media outlets that said, under the First Amendment, we have an absolute right to have this information. This is a public proceeding. George Santos is a member of the House of Representatives, which he disgraces every single day, but he is in a public position funded by taxpayers. The central issues here involve George Santos continuing to lie, continuing to hide the sources of his money. So the fact that he got $500,000 in a bond posted by three anonymous individuals is of additional public concern. And so that was the argument by the media interveners. Judge N.Y. Shields, Magistrate Judge N.Y. Shields, gave George Santos the opportunity to respond to the media interveners. George Santos' response was due last Friday. He asked for an extension of time so his lawyers can try to find case law that supports his position. He asked to have until Monday by 5 p.m. Eastern time. I think he missed that deadline, but his lawyer ultimately filed this letter brief. And that's how you do it in the Eastern District of New York and in the Southern District of New York. You file these letter briefs in case you're curious. Why would they send a letter? That's the format. But here is what George Santos's lawyer said in the letter brief trying to oppose the releasing of the names of the suretors. George Santos wanted to keep that a secret. Here's what his lawyer said. Here, in the instant case, the suretors are likely to suffer great distress, may lose their jobs, and God forbid, may suffer physical injury. There is little doubt that the suretors will suffer some unnecessary form of retaliation if their identities and employment are revealed. You need only to look at the declaration attached hereto as Exhibit A and other exhibits containing various threats made to Representative Santos, members of his staff, and even your undersigned, referring to the lawyer. The fact that someone emailed me my own letter back to me soon after I filed it with the court tells us that they're just ready and waiting to pounce. A few hours later, on Friday, June 2nd, 2023, I received a call wherein a male voice just shouted what sounded like, "Who paid Santos' bond?" Again, they are just waiting to pounce on these sureties. This is what the lawyer's letter to the judge. This was the argument that they were trying to make that was filed yesterday. In conclusion, Representative Santos' case has become what the Second Circuit Court of Appeals has referred to a heater case that involves a similar media frenzy. If this court is so inclined to unseal the sureties, we truly fear for their health, safety, and well-being. In fact, if the suretors are required to be identified, we respectfully request that the court allow the suretors notice before the court releases their information so they could withdraw as co-signers on the bond, and Representative Santos and I will appear before Your Honor forthwith. My client would rather surrender to pretrial detainment than subject these suretors to what will inevitably come. For the aforementioned reason, we respectively submit the motion that the motion to unseal should be denied. Well, Magistrate Judge Ann Y. Shields rejected this letter by George Santos and George Santos's lawyers. And I like that George Santos' lawyer said, my client, George Santos, would rather surrender to pretrial detainment than subject these suretors to what will inevitably come. How much do you want to bet that this is another George Santos lie? Let's see if he actually surrenders himself to pre-trial detainment instead of these names being released. And so ultimately here, this legal strategy, if you want to even call it that, by George Santos and his lawyer, backfired doubly, because now not only are the suretors' names going to be released, but here you have George Santos also saying that he would rather surrender himself to pretrial detainment. You know, the fact that he's saying that he would rather do that doesn't mean the judge is going to be like, well, I guess I can't release the name of these suretors now. I guess we're going to have to make a deal all of a sudden. No, these individuals put their name on public court documents. The damage was done. These individuals knew that George Santos was and is a traitor. They know that George Santos is a complete and utter fraud. They know the damage every day that George Santos is causing to our democracy and the mockery he is making of the United States of America. And knowing that, these three individuals said, we are going to put our names on a bond. We will deliver this bond in a public proceeding in a courtroom where things are generally public. Knowing that, they made that move. It was temporarily kept confidential, and now it is being released. The fact that George Santos says he would rather go to jail than have these names released doesn't freaking matter. What matters is they did it in a public forum, and we, the people, deserve transparency. We deserve the truth. And I know MAGA Republicans want to live in this Russia-style kangaroo court, whatever. That is not our justice system. And fortunately, frauds like George Santos are learning that now. So what happens next? We will see if George Santos essentially files what would be a challenge, if you will, to the magistrate judge's order to the district court presiding over the same case. District court presides kind of over the magistrate judge. So we'll see if George Santos challenges it there. I don't believe at all the district court judge is going to overturn or overrule what the magistrate judge did here. Potentially, George Santos can try to appeal to the Second Circuit Court of Appeals. I'm not fully sure that his lawyer, this Joseph Murray, who wrote this ridiculous letter, is even capable of filing an appeal based on the horrible work that I'm seeing in this letter. I'm setting aside that he's got a horrible client, but we will get these names soon. So buckle up. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Have a great day. Hit subscribe.
Hey, Midas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.